All right, officer, you open my courtroom, please?
The State of Michigan 36th District Court is now in session. The Honorable David S. Robinson Jr. presiding. Please refrain from talking until your case is called. Good morning, Your Honor.
Good morning. Okay, we are on the record with file number 20148-900. Could I have your appearances, please?
Good morning, Your Honor. Tricia Nelson, P68707, appearing on behalf of the plaintiff.
Good morning, Your Honor. Crystal Olmsted, P69202, appearing on behalf of the City of Detroit.
All right, are we done with our discovery in this file?
Your Honor, go ahead.
Oh, I'm sorry, go ahead.
I believe so, Your Honor. I know there was, I'm sorry, Your Honor, I was looking at the file. I believe so, Your Honor. Do you have any, Tricia? I mean, it's Ms. Nelson?
Yeah, as far as I know, we have sent the responses to you, and I believe discovery is all set.
Okay, then we'll close your discovery. One problem behind us. Now, let's give you guys another date. How about, since we're closed, you can now start taking a look at resolution. How about the 9th of December, which is a Wednesday? Does that work for both of you?
Give me 1 second, Your Honor.
Yes, Your Honor, that works for me as well.
Yes, it does.
All right, December 9th it will be at 10 o'clock. Let's see if we can't, now that our discovery is closed, let's see if we can't get this file settled. We'll set that one for a pretrial. If we don't get it settled, then I'll set the file down for a settlement conference, at which time I will require the trial counsel and representative of each side with settlement authority be present. Okay?
Thank you, Your Honor.
All right, then.
Thank you, Your Honor.
You two are good to go. Thank you for coming in. We're off the record in that file. All right, now where are you? All right, Mr. Sheets.
Yes, Your Honor.
Your case is 20240-481, is that correct?
Yes, Your Honor.
You're on the docket for 11/19, sir. Today is 11/17.
Thank you, Your Honor.
Have a good day.
You too.
All right. Mr. Barter,
Yes, sir.
why are you here?
Your Honor, I have portfolio recovery, last three digits 535 versus Janice Pearson.
Okay. I don't have your other side yet. We'll put you into the waiting room.
Thank you.
Mr. Anderson,
Morning, Your Honor.
good morning. And why are you darkening my doorstep today?
A pretrial on a open MRI of Livonia case.
Open MRI of Livonia?
Yes.
Where are you? I just lost you. Oh, I see you. What's the number on your file? 046?
Yes, it is.
Okay. I got you. Off to the waiting room for you.
Thank you.
Mr. Lennon.
Yes, Your Honor.
Good morning. Why are you here today?
I'm here on Silver Pine versus City of Detroit, 19-182833.
Okay. I don't have anybody yet, but we'll get you in the waiting room and we'll figure out where we're going.
Okay.
Ms. Khan, why are you here today?
Good morning, Judge. Same reason that Mr. Patterson is. It's a pretrial set for 10 a.m., Your Honor.
You're on that file with him?
I am.
Michigan Ambulatory?
Yes.
Okay, well, let's do you too then. Let's admit Mr. Patterson. He's already in, isn't he?
Yes.
Oh, okay. Let's get your file done. This is 858. Is that the last three digits?
Yes, Your Honor.
Okay, let's find your file. All right, here we go. All right, we are on the record calling case number 2015658. Michigan Ambulatory versus City of Detroit, your respective appearances.
Good morning, Your Honor. Michelle Khan for the plaintiffs.
Bar number,
75585.
Mr. Patterson.
Good morning, Your Honor. Gregory Pattison, P75963, here on behalf of defendant City of Detroit.
All right, this is 2015658. How are we doing on our discovery, folks?
We're doing okay, Your Honor. We submitted discovery over to defendant. Actually, it was last night or this morning. So Mr. Patterson should have our answers. So
Is that all? Is that now all our discovery done?
I haven't received anything from defendant, but we, although late, did submit our discovery to the defendant.
Mr. Patterson?
Your Honor, I can have everything because there is an underlying case in Wayne County. So I can just turn over basically everything from that file. And if Ms. Khan is agreeable, I could do it via email to expedite the process.
That's fine.
Okay, then let's get you guys another date and get you out of here. How about the 10th of December?
May I check my calendar, Judge?
Just check if you'd be so kind. I'd appreciate it.
Thank you, Judge.
Would that be at 10 a.m.?
Yes, it
Well,
would.
Your Honor, I'm scheduled to actually have the trial in 36 at 10:30 that morning. Whether or not that goes, I don't know, but.
Okay. We'll do it on the, does the 11th work for you?
Assuming that trial is complete, if not, Judge, I can certainly have someone from my office cover.
Ms. Khan, the 11th work for you?
Yes, Your Honor, I'll make it work.
All right, December 11th. At 10 a.m., we'll have our next pretrial, and your written discovery will remain open. Hopefully, you'll be able to both tell me that you're ready to close discovery the next time we're together.
Certainly, Judge.
Well, why don't I close it on December 10th? That'd probably be the best thing to do. Does that work for everybody?
That
That
shouldn't be a
works,
problem,
Judge.
Judge.
Okay. Then that's going to close out our docket on case number 858. And thank you both for coming in. We'll
Thank you,
send out a
Judge.
written notice.
Have a good rest of your day.
And you do the same. All right, Mr. Huff, you're here on Silver Pine Imaging versus City of Detroit.
That's correct, Your Honor. When I spoke to Ms. Ouellette yesterday, she said she had some other business with the court, so I thought she was going to
Okay,
appear.
I got here right now.
Oh, okay.
Ms. Ouellette? Hello?
Good morning.
Good morning. Let's call case number 191828833, Silver Pine Imaging versus City of Detroit, your respective appearances.
Could you say that case number one more time, Your Honor? I think I might have had a different case, might have a different case number.
Oh, is yours 191803326?
That's correct. Yes, Your Honor.
Is that your case?
Yes.
Okay, let's call file number 191803326, Silver Pine Imaging versus City of Detroit, your respective appearances.
Good morning, Your Honor. Dustin Hoff on behalf of the plaintiff, P number 78246.
Good morning, Your Honor. Teresa Ouellette, P72765, appearing on behalf of defendant, City of Detroit.
Okay, now I understand this case has been settled.
That's correct.
Okay. Mr. Hoff, you guys have settled the case?
Yes, Your Honor. We've settled the case and we have sent corresponding emails confirming the settlement.
Accepting your representations as the officer of the court will dismiss 191803326 without prejudice. When you have finished your paperwork, you can send in your final original dismissal with prejudice, because I know it takes a period of time for your paperwork to catch up with the file. Is there anything else we can do today for you, Mr. Hoff?
No, Your Honor. Thank you for your time.
Ms. Ouellette, I understand you have another file?
I have two others. Yes, Your Honor.
You have two others.
I do.
Oh, okay. Well, let's get them done. And let's do one thing at a time.
Yes, Your Honor.
Did you settle your other cases as well?
I did not, Your Honor, unfortunately. I know. I tried.
Come on, we need success.
I know.
It's only, as I recall, it's been a while since I've been in school, but I think it's only in elementary school that they grade you on effort.
You're right.
I think everywhere else they expect results.
Right.
Now, what file do you have, Ms. Ouellette?
I have the first one is spine specialist. It's
Okay.
20.
I had him, where did I put him? Oh, no, did I lose him? Oh, I have Mr. Gould for that.
Yes.
Okay, let's get him in here and let's get started.
Perfect.
Unmute, Mr. Gould.
Good morning again, Your Honor.
Okay, I think I have both sides on your file. This is 201585552, spine specialist versus City of Detroit. Is that the right case?
That is correct, Your Honor.
Could I have your appearances, please?
Jeff Gould, P number 83699 on behalf of Spine Specialist of Michigan.
Good morning, Your Honor. Teresa Ouellette, P72765, appearing on behalf of defendant, City of Detroit.
Okay, give me just a second.
Yes, Your Honor.
Now, where are we on our file?
Your Honor, we've exchanged discovery in this matter, and we've even spoken regarding settlement negotiations. I am in the process of obtaining two cashed checks because it appears that two of the bills claimed have already been cashed in this matter. So we may, if we cannot agree on an accordance satisfaction regarding those two bills, I may need to present, Your Honor, with a motion, and that would leave one outstanding bill that I was attempting to negotiate.
All right, what's the story on her claim about paying 2 out of the 3 bills, Mr. Gould?
I've contacted our biller regarding that. I'm not sure whether there were 2 checks cashed or not. I I'm only aware of the outstanding balance for the underlying patient in this matter, but I have sent out a request to the biller regarding that specific matter.
When are you going to hear back?
It usually will happen either sometime today or at latest early tomorrow morning.
Okay. How about I have you guys back then on December the 10th, so we can see where we're going on this file.
Okay, Your Honor.
Does that work for everybody?
That works for plaintiff, Your Honor.
Ms.
That's the
Ouellette?
December. Yes, Your Honor.
Okay, December 10th. 2020 at 10 a.m. We'll have our next pretrial and we'll see about bills paid.
Yes.
Is there anything else we can accomplish today?
That should be all that I'm aware of, Your Honor.
No, Your Honor, that's all.
Okay. Then, Mr. Gould, I'm going to release you.
Thank you.
And Ms. Ouellette, I have a couple more matters with you apparently. So
One more,
we'll put you
Your
in the
Honor.
waiting room.
Have a good day.
Okay, you too. Thank you, sir. Move Mr. Gould, Ms. Ouellette in the waiting room. Abro and Hiltner. Abro and Hiltner. Ms. Abro,
Good morning, Your Honor.
Mr. Hiltner. Are you there?
Good morning.
This is case number 20160-337. Focus Imaging versus City of Detroit. Your respective appearances, please.
Good morning, Your Honor. Christina Abro here on behalf of Focus Imaging, P78224.
Philip Hiltner for defendant City of Detroit, P77913. Good morning, Your Honor.
Good morning. Where are we on this file?
We are working on discovery, Your Honor, at this time. We're getting together mandatory disclosures, and I have sent out defendants' discovery via mail.
Okay, the only discovery that I opened here and did it purposely was the disclosures under 2.302. And they would have been done by today. Well, no, you had 21 days to do that. So I think.
Discovery issued to us, Your Honor?
No, I didn't open discovery at all, with the exception of ordering the MCR 2.302 disclosures to be made by both sides within 21 days of that October 15th order. So it might be a little bit short. You might not have had enough time to get it done. But that at this point in time is the only discovery that I'm contemplating authorizing in the case. Now, you, of course, are free to do any kind of discovery you choose by stipulation. But it appears to me, and again, I'm new at this, is my new PIP philosophy. It appears to me that I was spending a great deal of time in unnecessary arguments about discovery, most of which would have been resolved had the party simply made the 302 disclosure. And for some reasons, when they decided to write the courtroom, even though the discovery in the PIP cases in the district court is pretty much the same as in the circuit court, they left us out of the mandatory disclosures, but permitted me to order those disclosures. So that's what I've done. So what I want to get done here is I want to get those disclosures done, get them out of the way so that we can get moving on this file. So why don't I give you guys a return date and get you on the way? Does December the 10th work for both of you?
Let me just check.
December the 10th is actually, not a good day for me. I have other hearings that morning.
December 22nd. Does that work for both of you?
That works for me, yes.
And Ms.
That-
Abbo?
Yes, that works for me, Your Honor.
December 22nd it is.
Is that at 10 a.m. as well?
Yes, you're on my 10 a.m. call here. Let me give you a little insight to how I try to run my docket. I have a 10 and an 11 o'clock call, and I typically will keep you on the same call until we get our case resolved. So we'll see you December 22nd at 10 a.m. And I need to get those 2.302A disclosures done.
Yes,
Okay?
that. Sorry.
That's Mr. Hilton, go ahead.
Oh, no, I was just saying, understood, Your Honor. The city will make sure we get our disclosures out shortly.
Okay.
We'll send ours out as well. Thank you.
Okay, good. Then I'm going to release both of you. Thank you for coming in and be safe.
Thank
Great,
you.
thank you, Your Honor.
Mr. Gantz? Mr. Gantz?
I'm sorry, I'm on the record at the moment, Your Honor, in Dearborn. Can I?
I'll get back to you.
Thank you.
Ms. Beverly? Hello? Ms. Beverly? Mr. Anderson?
Yes, Your Honor.
You're on open MRI versus endurance property. East area. Ms. Beverly, is that your case?
Yes, it is. Morning. Harold Beverly on behalf of the plaintiff, P44028.
Let's call the file, since it took me a while to get you guys here.
Oh.
Let's call case number 2015846. Open MRI of Livonia versus Esurance Property. Now, if we could have your appearances.
Good morning. Harold Beverly, P44028 on behalf of the plaintiff.
Good morning, Zachary Anderson, P71605 on behalf of Esurance.
And you came in to tell me you settled your case, right?
Well, I've tried my best, but alas, got to go a little bit longer. I have sent discovery to defense counsel. He has not answered, but he said that he needs 14 days. I was in the process of sending him over a stipulated order saying that he would give the discovery responses by December 1st. I don't know that he would be willing to sign it. If not, I'll file a motion. But
Your audio cut out. I couldn't hear you.
Is the discovery overdue?
It is overdue.
Okay. She wants to send an order that you'll answer by December 1. Is that agreeable to you?
Yes, I did ask her via email to send me a stipend order for review.
Okay. See how easy this is? This isn't even complicated. All right. So December 1st, we're going to have our discovery done. So how about I have you guys back on December 10th?
that's fine by me.
And Mr. Anderson?
That is fine. I don't have any written outstanding discovery from her. There is one report that I'm just waiting on, a billing and coding review.
Well, you didn't send any discovery out at all, any written discovery at all, but I'm willing to give you what I have at this point, which isn't very much, but I'm happy to send it to you. but I don't have, if you sent written responses, I don't have them.
Oh, no, I said that you don't owe me anything.
Oh, I'm sorry. I apologize.
It's all right.
Okay, let's get our work done. December 10th at 10 o'clock, and you guys will be sending in that stipulated order concerning the outstanding discovery that Mr. Anderson owes. Is there anything else we can accomplish today?
No, thank you, Your Honor.
Anything for you, sir?
No, thank you, Your Honor.
All right, thank y'all both for coming in. Have a good day and be safe.
You as well.
Honor.
Mr. Brado,
Yes, sir.
you are here on
Portfolio,
535.
that is correct, Your Honor.
We are on the record. This is file number 1916655. The file is entitled Portfolio Recovery versus Janice Pearson. This matter, by a notice dated October 9th, 2020, is set for Zoom hearing today, November 17th at 10 o'clock. It's now 10:33. Your appearance.
Good morning, Your Honor. Sazan Barda, P65425 on behalf of Portfolio Recovery Associates.
We have not had an appearance by Ms. Pearson. Have you received any pleadings from her?
No, sir.
You want to set aside a satisfaction?
That is correct, Your Honor.
Why is that, sir?
Your Honor, the defendant resolved this matter with us for $1,069. She made that payment on July 2nd. 4 days later, pursuant to our guidelines and consumer protection laws, we need to report within 14 days to credit agencies and to courts to get things resolved. So we sent in our satisfaction to judgment 4 days later on July 6th. And then 3 weeks later, that check ended up being non-sufficient funds in our office. So we are now asking for that satisfaction to be set aside so that we can pursue this matter.
All right, the first thing I would suggest is that you consider pursuing with your legislative bodies a reform of the statute so that your reporting obligation would be either 14 days or until the check clears, whichever is later.
We were talking about that yesterday, Your Honor. I wish we could wait for payments to clear. Unfortunately, the rules don't allow us to do that.
I understand that is the current state of the law, but laws are made by men. They don't come down from tablets of Mount Sinai.
That's true.
Somebody talked to their congressperson and got this legislation passed.
That's correct.
Your association ought to consider saying, hey, now that we have some experience with this, we need to change it. We need to be in a position to either pay within 14 days or after the check clears.
Absolutely.
So maybe somebody will come in and they'll pay cash. Obviously, that should be paid, taken, cleared up in 14 days.
Of course.
If you have to wait till a check to clear, that ought to be the trigger time for your reporting obligation, not just an absolute calendar date. But since I'm in the judicial business, not the legislative business, this is something you guys need to take up with your lobbyists. In any event, your unopposed motion to set aside the satisfactory judgment in this matter is granted. Court has a proposed order from your motion. We'll send it on out. Thank you for coming in.
Thank you, Your Honor. Have a wonderful day.
You too, sir. We're off the record for you. You're free to go, sir.
Thank you, Your Honor.
All righty. We are on the record with my remaining 10 o'clock. Silver Pine Imaging versus City of Detroit. This is case number 1918283. Your respective appearances.
Adam
Your Honor.
Gates, the plaintiff, P58558.
Your Honor, Stuart Levitt, I'm also appearing on behalf of the plaintiff, Your Honor.
Are you a
Morning,
member of
Your-
State Bar of Michigan?
42879, Your Honor.
Ms. Oulette?
Good morning, Your Honor. Teresa Oled, P72765, appearing on behalf of defendant City of Detroit.
All right, we have a couple of matters before us today. Our written discovery is closed, so we have to talk about where we are in settlement. But before we get to that, there's an outstanding motion for attorney fee Mr. Lenenbaum had filed. Sir, have you and Ms. Oulette resolved your motion?
We have not.
Sir, your motion.
I don't believe there was a response filed or an objection filed to the attorney fees that were submitted. If so, I didn't receive it.
Stop. Did you file a written response or objection, Ms. Oulette?
I did file it. Well, my secretary filed a written response.
When was that?
I believe on Friday.
This past Friday?
Correct.
For a motion that was calendared a month ago?
Your Honor, we did not receive the motion when it was calendared a month ago. That's why you adjourned it to this date.
The first
last
motion was
a month ago, we emailed.
calendared on October the 12th for the 20th, and on the 20th, we adjourned it to today.
That's correct, Your Honor, because on October the 20th, we had not received a copy of the motion.
But you did receive an email of the motion from me within 24 to 48 hours of our last hearing before this court.
That's correct.
Okay, so Your Honor, there was no written response that I've received. I don't think the court's received it. There was a default set aside in this matter. While this court was gracious enough to set it aside, the court rule MCR 2.603D requires that that order be conditioned upon payment of costs and reasonable attorney fees. And what I did in order to be what I felt was abundantly reasonable is I very much detailed all the time that I put in on this matter. And it was a total of 11.6 hours. And it's not including the 3 times that I've appeared for hearings on this regarding the attorney fee issue. I didn't include that, but my standard hourly rate is $3.25 per hour. I've been practicing over 30 years. I without sounding egotistical, I am a top litigator in this state. I have often had years where I have been one of the top attorneys in terms of verdicts, 7-figure verdicts. I've been an attorney general, special assistant attorney general for 29 years. I've represented many states in terms of their efforts to collect taxes in the state of Michigan, as well as the state of Michigan. I currently represent many major corporations. And my standard rate is $3.25. I haven't raised my rate in like the past 15 years. If you look at the median rate in the state bar journal, it puts it at about $2.50. I'm only billing this at $2.25 per hour, and I've got 11.6 hours in there, and I've detailed my time. I think that $2.25 is really a bargain, and I really bent over backwards to be, very fair and very reasonable on my charge in this case. And I'm asking this court award $2,610 for the 11.6 hours that I've incurred, and attached to that I've a detailed billing and the 2017 economics of law practice, which indicate what attorneys generally charge in Wayne and Oakland County. And you'll see the median rate is $2.50. And I think I'm well above the median. I mean, I'm a principal attorney managing and operating 2 law firms, one of which is in 9 states and has approximately 100 employees currently. And then, I also operate an office in Troy, and I'm a principal, Your Honor. I'm not an associate, and I think the $2.25 for my time and the amount of hours I put in are reasonable under the circumstances. And I'd ask the court to award $2,610.
Yes, Your Honor. The City of Detroit objects to any award of attorney fees in this matter. As Your Honor had stated and confirmed when we were at the motion hearing to set aside the default in this matter, the City of Detroit never received notification of the pretrial hearing. The City of Detroit had been actively participating in the litigation of this matter. With the exchange of discovery, we had just filed our responses to requests for admission in this matter. prior to the pretrial hearing having been heard. We didn't get notice, and therefore the city should not be penalized for not showing up for a hearing for which the city had no knowledge of.
Mr. Levenbaum.
Your Honor, she's arguing the motion again. The court has already determined that we're entitled to reasonable attorney fees in accordance with the court rule. The only issue before the court is the presentation supported by the record? Is the rate that I'm requesting reasonable? The amount of time that I put in reasonable? And I think that the hours are reasonable and the amount that I'm requesting is reasonable.
All right, thank you. The court has had an opportunity to review the pleadings filed on behalf of Mr. Levenbaum in this matter. No written response has been filed on behalf of the city of Detroit. Mr. Levenbaum is correct. The court had previously determined that under 2.602, the defendant was required to pay attorney fees. Given Mr. Levenbaum's time of 11 and a half hours, an hourly rate for an attorney who admitted more than 30 years of $225 is more than reasonable. The court finds that under 2.603D, and I previously erred saying 2.602, it should have said 2.603. Under 2.603D, attorney fees will be assessed against City of Detroit and in favor of Mr. Levenbaum in the amount of $2,610. You can submit a written order to that regard, sir. And of course, Mr. Roulette, as always, anyone who disagrees with my Solomon-like decisions has an absolute right to appeal.
Your Honor, how many days will the city of Detroit have to pay?
I'm going to leave. I'm going to not leave that in the order. Just make it forthwith in your order.
Thank you, Your Honor.
See, because the problem that they have is that there's a city council process that has to occur, and we're going into the holidays, and I don't want to put the city in a position where it's impossible, because it may very well be city council may be on leave during that time. Okay, that's all for you, Mr. Olette. Mr. Levenbaum, you're free to stay or go as you choose.
Thank you.
Let's move forward, Mr. Gantz. Good morning, sir. Your appearance.
Adam Gantz, for the record, on behalf of the plaintiff. I believe that was the only outstanding issue. I believe discovery's been resolved. I know opposing counsel indicated that she didn't receive it, so I emailed it to her after the last hearing, our responses. So I think they have all of our trial documents there.
All right, let's stop here. Mr. Gantz, what's your bar number?
58558, Your Honor.
Go ahead.
So I think we're ready for trial. I want to point out to Ms. Willette that I made a demand to her this morning. We did communicate. I wasn't clear. That demand was inclusive of attorney fees.
Okay.
If that
now, let's do this. Ms. Willette, what is your position? Is your discovery completed?
Our discovery is completed, Your Honor. We did.
Okay, here's what we're going to do. I'm going to close your discovery. I'm going to give you a return date of December 23rd. Does that work for everybody?
Works for the plaintiff.
Ms. Willette?
Yes, Your Honor, that will work for me.
December 23rd at 10 a.m. we will have our last pretrial conference. Your discovery is closed as of now. The purpose of that pretrial conference is to see if we can't get the file resolved. If we cannot get the file resolved, then I'll set it for a settlement conference, at which time I will require the trial counsel and representatives of each side with full settlement authority be Zoom present. I used to require physical presence, but we're not doing anything physically this year. Could you hold for just a second, please?
Sure.
Financial people are like bed bugs. They never go away. Let me send you guys out a notice. December 23rd at 10 o'clock. Now that our discovery is closed, we may be in a position to move forward on resolution on the file, given the fact that we now have our really outstanding matter in relationship to Mr. Levenbaum resolved. So let's get this file done and see if we can't get it closed out.
Great.
Anything else we can do today?
No, Your Honor.
Okay, thank you both for coming in.
Thank
We're
you.
off the record for both of you. I'll have still the 11 o'clock call, but you guys are free to go.
All right.
Have a
Happy
good day
Thanksgiving, Your Honor.
and be safe.
And same to you.
Do me a favor, guys, don't talk too loud because I think they can hear.
All right, Mr. Bedouin, who are you representing today?
Midland Funding?
On case 630?
Yes.
Okay. Put you in my waiting room.
Thank you.
Where'd you go? Oh, here you are. Mr. Reed, who are you representing today?
Good morning, Judge. I'm representing Open MRI.
Okay. I don't think I got your other side yet, so I'll put you in the waiting room as well.
Okay.
Mr. Reddick? Mr. Reddick, who are you representing?
Yes, Your Honor. Citizens Insurance Company.
Oh, okay. I got both sides when you guys in, okay?
Oh, okay. Yes.
We can get you and get Mr. Reed. We can get started.
Thank you.
I'm having a little technical difficulty here, guys. Bear with me. Okay, I think I got you.
I can hear you.
Okay, let's call your file. This is 201600566. Open MRI of Livonia versus the Hanover Insurance and Citizens Insurance Companies. Your respective appearance.
Arnold Edward Reed II for the plaintiff, P4142, 84142.
Good morning, Your Honor. Matt Reddick on behalf of both defendants.
All right, gentlemen. Where are we on this file? Is our discovery done? I'm sorry, actually, just so the record is clear, when the court sent out notice of today's proceeding on October 19th, I gave the parties 21 days to make the disclosures required by MCR 2.302. More than 21 days have elapsed. Has those disclosures been made?
Well, Your Honor, we just have an answer from defendants, and I believe that I don't have anything other in the file, anything else in the file, Your
Mr.
Honor.
Reddick?
No, Your Honor. It appears neither party has provided those. I can certainly do that this week.
Mr. Reed, why have you failed to do that?
Your Honor, there's no good reason, but we can't do that as well this week.
Well, gentlemen, we can't get things done. We're not going to do discovery, or unless you'd rather me just close and do it without discovery. We can do that.
No, Your Honor, I prefer the other way around. The other, and I will provide those. The other thing that may be an issue is, I believe that the amount at issue is now above $25,000.
Mr. Reed?
I believe that counsel is right, Your Honor.
Okay, but here's where we are. I will have in my hand by Friday an order of transfer, or Friday at noon, I will dismiss this matter for lack of subject matter jurisdiction. Are we all clear on this?
Yes, Your Honor.
Yes.
So I guess you have to go fight somewhere else.
Will do.
Thank you, gentlemen.
Okay, thank you, Your Honor.
Have a good day.
Yep, bye-bye.
Let's get started. Who is at Galaxy Tab A8?
Mr. Melton Hagood, sir. Melton Hagood.
Okay. Hang on. Put you in the waiting room. And who's at LG Aristo? I can't hear you. You have to unmute, sir. No, talking louder doesn't do it. Unmute.
Okay.
Try it again. What is your name?
Karan Richardson, Your Honor.
Quran.
Mr. Richardson, I believe I have both sides on your file. So I'm going to put everybody else in the waiting room. I mean,
Okay.
and we'll get you on the work because I have the other side for your file.
Okay, Your Honor.
And where did Mr. Bedouin go? Okay, I think I have both sides on this file. This is case number 2015160, Midland Funding versus Karan Richardson. Could I have your respective appearance?
Good morning, Your Honor. Sean Bodwine, E71644, on behalf of Midland Funding.
And your name, sir?
Karan Richardson?
Is it your intention to represent yourself in this matter?
Yes, yes, Your Honor.
Sir, you have an absolute constitutional right to do that. What you do not have is the right to your own set of rules of civil procedure, your own rules of evidence, and your own statutes. If you elect to represent yourself, as is your constitutional right, the same rules that bind counsel will bind you. You understand that?
Yes, Your Honor.
All right, gentlemen, where are we on this file? This appears to be our initial pretrial. Where are we?
Well, we have not had a chance to speak. I don't know if you would like to try to make a settlement arrangement or not, but we are more than willing.
You want to try to do that, Mr. Richardson?
I sent the response to his complaint, and I was asking for an accounting of where the money was spent because I remember paying that credit card off at one point.
Okay.
But I never received the account statement to show where the money was spent after I paid it off, you know? So at this point,
So we're not at a point where you guys are really talking about someone realistically. So what I'm going to do is I'm going to open your written discovery. And I'll give you gentlemen a return date. Oh, return date. Does December 11th work for both of you?
Yes.
What about
Yes.
you, Mr. Bedouin?
Yes.
December 11th at 11 o'clock it is. We will do our next pretrial on December the 11th at 11 o'clock. Your written discovery is now open, gentlemen. I will send out an order and we will get you gentlemen on your way today. Thank you for coming in.
Thank you, sir.
We are now off the record. All right. I have, I believe, Richard Clay and Milton Haygood on the 2014-2292. Who is Tina Lacey Clay?
Your Honor.
Richard,
Okay, go ahead. I didn't know you were on.
yeah, it just popped me on, Your Honor. I'm Richard Clay.
Okay.
Tina Clay is my wife.
Okay, she's not a party here.
Yes.
All right, ma'am, you're certainly welcome to watch. Court will mute your microphone because you're not permitted to participate. But you're certainly welcome to attend by Zoom. So I believe I have all of you now in the court.
Yes.
Okay, let's call your file. Calling case number 20142-972, Melton Haygood versus Richard Clay. Your respective appearances, gentlemen.
Richard Clay.
Mr. Haygood, your appearance. Mr. Haygood. Hello.
Yes, sir, I can hear you, but you're not coming through too well, sir.
All right, your appearance, sir.
I can.
All right, I'm going to put him in the waiting room and try to bring him back. You guys stay where you are, okay?
Okay.
I had him a minute ago. Let's see if this works better. All right, let's call your file. This is 20142-972. The file is entitled Melton Haygood versus Richard Clay. Your appearances.
Richard Clay.
I can't.
Milton Haygood.
All right. Where are we, gentlemen? You had, last time we were together, you indicated that you had a landlord-tenant matter that was coming up.
Yes, sir. We had a landlord-tenant case last week. Mrs. Judge Millhouse have ordered to sign the writ of order of eviction, and that would take place on January 2nd. The case was also brought up, the one that you got in your courtroom right here, and she let Mr. Hagood know that there's not a retaliatory case against me because we already had paperwork and a case signed before he made his filed his claim with you. The thing was that we had to adjourn that first case and start a new case due to a technicality. So I'm asking the court to dismiss this case right here, Your Honor.
Mr. Hagood, is that what the judge told you? Mr. Hagood? Where'd he go? Mr. Hagood?
I'm right here, sir. Is it possible?
Is that what the
Yes,
judge
sir. May I
told you?
speak?
Is that
No, sir, it isn't. That is not the way I understood it.
Were you in court?
I was in court. My understanding is that there was a writ signed for January 2. However, I don't remember hearing anything her saying I did not have a legal case. My case is for a lawsuit and for retaliation. That's what I'm suing for. I'm not suing in landlord tenant court. It was referred to your court because under 36th District Court record, we have a right to file a civil action suit against the landlord, which is what we're doing.
As I understood, excuse me, Mr. Clay.
Yes, sir.
I think the best thing would be for you both to obtain a transcript of what the judge ordered. Because if the judge has already ruled there's no retaliatory case here, then there's no reason for me to proceed with this case. But you gentlemen appear to have a difference of opinion on what it is that the judge ordered. So this is how we're going to resolve it. Mr. Clay, order a transcript from that hearing.
Yes, sir.
That way it's submitted to the court. That way, because if she's already ruled there's no retaliatory case, then there's nothing, the case is decided already.
Okay.
There's nothing I can do here. Mr. Hagood's case will have to be dismissed if another judge before me has already ruled that his case is not valid. That's the way it's going to be.
I agree.
So what I'm going to do is I'm going to adjourn the matter until December the 22nd. That'll give you time to get the transcript and submit it to the court.
Okay.
So you understand? Because the court,
yes, sir.
There's already been a ruling here.
Yes, sir. It was the second case, Your Honor. I understand. I understand exactly what you mean.
Yeah, she made a ruling in her case about this case.
Yes.
Then so be it. So I'll adjourn the
Agreed.
matter until December 22nd, and I'll just note that we're going to have a transcript here.
Agreed.
10 degrees. All right, gentlemen. Ms. Clay.
Thank you so much, sir.
December 22nd at 11 o'clock. I'm going to send out written notice to both of you. Thank you for coming in.
Thank you so much, sir. You have a pleasant day.
Be safe.
You as well, and your family.
He's not always serious with her, right? He still plays with her. Oh, you're doing hot dog and sausage? Okay. I want both. I want to lose 5 pounds. Yeah, quit the candy.
Are we ready to begin, gentlemen?
Good morning, Your Honor.
Good morning, Judge. How are you today?
Let me call your file. This is 19175-025. Saad Istefan versus Marvin Shea. Could I have your respective appearances?
Good morning, Your Honor. Raymond Sloom on behalf of the plaintiff, Mr. Istefan, who's also present.
Mr. Istefan?
Yes, Your Honor.
Mr.
I'm
Saloon,
sorry.
no, you're fine, Mr. Istefan. I'm talking to Mr. Saloon. He needs to tell me his bar number for the record.
I'm sorry, Judge. 36852.
Mr. Soroki?
Yes, Alan Soroki, P37441, appearing on behalf of the defendant, counter plaintiff, Your Honor.
And Mr. Shea is here, labeled administrator. I don't know how that happened.
Happens every time. I don't know why.
It's really odd, really odd.
It literally happens every time.
Now, is it only on this, when you call this court, or when you use other Zoom somewhere else?
This is the only court that I've used, so I don't know why it keeps popping up.
Don't worry about it. We're all here. Okay, when we were last together, we had been moving on the settlement path, then we seem to have gotten sidetracked. And so we're trying to get back on path. How are we doing on getting resolution here, gentlemen?
I don't think there's been any movement, Your Honor.
I apologize, Judge. We have tried. We are drifting further apart.
Well, that's one of the things that doesn't make sense to me. This is a dispute about money. In the American legal system, each side pays its own attorney fees in the absence of a statute or some specific court rule. And here, neither of those are applicable. So there's no change in the amount of money at issue in that regard. The amount of money at issue is whatever that amount is. That doesn't change. And we are not in the hurt feelings, wasting my time. I don't want to deal with this, or I'm mad at that person business. We don't do that either. This is not a playground. This is a courtroom. Given the fact that the amount of money at issue has not changed, the idea that you're moving further apart is ridiculous. It's absolutely ridiculous. But I think you are where you are. Now, here's the situation, and I presume you're all adults. If not, I'm sorry. You know or should know what's going on in terms of the pandemic going on here in the state of Michigan and indeed across the country. There's not going to be an in-person trial here. My guess is before June of next year, if, emphasis on if, we get back to that. I think all we're going to do is Zoom. We had a new directive just the other day in light of the things that the Department of Public Health just ordered from the court, and remote is going to be what it is, gentlemen. Remote is going to be what it is because it's all we have. So while I have the four of you together, I'm going to put you in a chat room for you to talk with each other. Now, I've already talked to both of you about how the settlement process works. You remember the things I said, Mr. Shea?
I do.
And what about you, Mr. Stefan? You remember the things I said?
Yes.
Now, here's the deal. You're not going to get a court date anytime soon. Unless one of you has a couple million doses of a vaccine in your back pocket. We're just not going to do anything. I'm sorry, but we're not. let me put you in the chat room. Let you guys talk about this and get started on resolution. This is not going to be, oh, happy day, I got 100% of what I want. Let me tell you right now, everybody is going to be unhappy. That is the nature of settlements. Plaintiff says I didn't get enough. Defendant says I paid too much. Everybody is unhappy. That's the world in which we live, gentlemen. Let's get you in the breakout room and see if we can't get you done.
Joy.
I didn't get an administrator. What happened to the administrator? Let's try to get you in there. Where's the administrator? Here you go.
Do you want me to log out and log back in?
No, I'm going to put you in number one.
Okay. Oh, here, it says join.
On the record, we seem to have everyone here. Gentlemen, how do we do?
Well, we had a good discussion, but unfortunately, we do not have an agreement. We might be a little bit closer than we were at the start of the discussion today.
All right, we'll try it again. Does December the 23rd work for all you gentlemen?
I'll let you know. I have surgery scheduled. I have not picked a date, or they haven't picked a date yet. So I don't know how long I'll be out. Maybe I could Zoom through my bed. I don't know. It's a back surgery. So I would keep that date, and we'll I guess maybe I can contact my attorney to see when they give me a surgery date.
Unlikely they're going to do it on the 23rd because that's so close to the holiday. They're not going to they have to pay overtime for staffing. So they're not going to try to have you in the hospital during that time, during that holiday season.
Okay.
December 23rd is good for me, Your Honor.
Okay.
That's fine with me, Judge.
How about you, sir?
Yes, sir.
All right, now let's get this done, gentlemen. I'm the only guy here who can do this indefinitely. Okay?
Okay.
You ever walk a drunk friend home from the party? He doesn't fight you, but he just dead weight. This case is just dead weight dragging you guys down. It's time to move forward.
Yes, Your Honor.
It's not going to be a perfect world. And because it's not a perfect world, it's not going to be a perfect resolution. The object of the exercise is a resolution we can live with, not something that's going to have you shooting off fireworks and having a parade down Woodward. Of course, you can't do that anyway, but anyway. December 23rd at 11 o'clock, gentlemen, we'll try it again. In the meantime, let's keep working on resolution and make sure you're staying safe. Wear your masks, practice your distancing, and wash your hands. And we'll see you December 23rd at 11 o'clock.
Thank you.
Thank you, gentlemen.
Have a good
Thank
day.
you, Your Honor.
Everybody.
Thank you.